5 seconds to go. Start. In fact, the officer of such high rank is required to decide about the approval even for recording of FIR in relation to any offence under the MACOCA. Stop. This obviously discloses that the approving authority has to apply its mind about the applicability of the provisions of the MACOCA to the facts disclosed in a matter before allowing the recording of FIR, and for that purpose, he must be, prima facie, satisfied about the commission of offence of organized crime under the MACOCA by the person or persons against whom the FIR is to be recorded. Stop. Obviously, for prima facie satisfaction regarding the commission of the offence of organized crime or of participation therein in whatever manner, the approving authority must have some materials before it disclosing the activities of the person or the persons to be of the nature of offence under the MACOCA and having committed such activities on or after 24th February 1999. Stop. In other words, the activities of a person to be termed as the offence under the MACOCA, the same should inevitably disclose to have been committed on or after 24th February 1999. Stop. If the activity of the person is relating to the period prior to 24th February, 1999, obviously, it cannot be said to be an offence under MACOCA Act, even though the activity may be an offence under the provisions of some other statute in force at the relevant time. Stop. Para. Thus, the High Court took the view, relying on its various other decisions, that if no illegal activities as contemplated by MACOCA are shown to have been committed after 1999, then the past activities prior to 1999 may not be of any help for registering any FIR only on the basis of such past activities. Stop. Further, if two or more illegal activities are committed after 1999, then the past activities can be taken into consideration in order to show the continuity. Stop. Para. The state of Maharashtra, being dissatisfied with the aforesaid judgment of the High Court of Judicature at Bombay, challenged the same before this court. Stop. It is the said challenge which culminated in the decision titled as Shiva alias Shivaji Supra. Stop. Para. We now proceed to look into the relevant observations made by this court as contained in paras 9, 10 and 11 respectively. Para. It was in the above backdrop that the High Court held that once the respondents had been acquitted for the offences punishable under IPC and the Arms Act in crime numbers 37 and 38 of 2001, and once the trial court had recorded an acquittal even for the offence punishable under section 4 read with section 25 of the Arms Act in MACOCA crimes numbers 1 and 2 of 2002, all that remained incriminating was the filing of charge sheets against the respondents in the past and taking of cognizance by the competent court over a period of 10 years prior to the enforcement of MACOCA. Stop. The filing of charge sheets or taking of the cognizance in the same did not, declared the High Court, by itself constitute an offence punishable under section 3 of MACOCA. Stop. That is because the involvement of the respondents in previous offences was just about one requirement, but by no means the only requirement which the prosecution has to satisfy to secure a conviction under MACOCA. Stop. What was equally, if not, more important was the commission of an offence by the respondents that would constitute committing unlawful activity. Stop. So long as that requirement failed, as was the position in the instant case. Stop.